What drives a lifelong, law-abiding, retired member of the public to smash a window, remove costly nameplates, bring the City of London to a very costly standstill, and suffer the huge inconvenience and cost of producing a film? Well, I can assure you it was little or nothing to do with the trivial amount of money involved. It was the fact that I had been deceived by my trusted family solicitor, who fraudulently stole money from trust and perverted the natural course of justice. This deception was compounded by the Law Society and its senior members supporting Leedsday's fraud, theft, and perversion of justice, thus destroying my faith and trust in our legal profession and system. It appears the Law Society decided I did not have a right of passage to justice. They decided I was a nuisance, a barnacle on their boat of justice. Necessity compelled me to do these dreadful things, and invest 10 years of my well-planned retirement pressing and insisting the Law Society do their duty as decreed by Parliament, and provide 3 simple honest answers to 3 simple honest questions, and ensure the perpetrators are reported to the police as per the ACPO Memorandum of Understanding, and prosecuted. The question that needs to be addressed is, why has the legal industry squandered so much money to cover up unlawful acts? To quote Lord Denning, the law was to serve the people, not vice versa, and no one was above it. When dealing with solicitors, the Law Society, or any member of the legal profession, caveat emptor, or buyer beware, should not have to be considered, even remotely, by a layperson. My trusted family solicitor, Leedsday, fraudulently stole from money they retained on trust for a particular purpose, and went on to pervert the natural course of justice in Peterborough County Court. I, the victim, was driven to such extreme measures by the extreme dishonesty of Leedsday, the Law Society, and the legal profession in general. This situation was seriously compounded by the most powerful trade union in the world, the Law Society, who conspired and supported Leedsday's unlawful acts. These extreme circumstances needed extreme actions. In smashing Leedsday's window, I was doing no more than following the example set by my trusted family solicitor, Leedsday. That is, if you don't succeed within the rule of law, ignore the law. In removing the nameplates from the Law Society offices, I was doing no more than following the example set by the Law Society. That is, if you can't succeed within the rule of law, ignore the rule of law. When demonstrating outside the Law Society offices in Chancery Lane, I was doing no more than following the example set by Leedsday and the Law Society. If all else fails, try terror and bullying. Instead of resolving the issue amicably within the first 3 hours of my demonstration, the Law Society inveigled the Metropolitan Police into taking action. This film is to lay before you as many facts and as much evidence as time permits, so you have the opportunity to judge the facts and see if you agree with the 2-tier legal system operated by the legal industry. I didn't, and was sent to prison. In my opinion, the laws of the land have been hijacked and manipulated to fill the deep pockets of a small, selfish group within the legal industry, who consider themselves to be above the law. In 1986, the Law Society were very pleased to accept the privilege and responsibility of self-regulation bestowed by Parliament. However, it was not long before the Law Society betrayed Parliament's wishes by considering their trade union obligations to be more important and above their legal duties to Parliament and we the public. Fraud and theft are very serious crimes and must be viewed even more seriously when perpetrated by members of the legal profession. However, even more serious is the crime of perverting the natural course of justice, particularly when perpetrated by solicitors, who are officers of the court. when the perversion of justice is aided and abetted by the Law Society, it becomes serious beyond belief. Nevertheless, such unlawful acts are clearly documented and must be exposed. This country, the mother of democracy, should and must be above all such evil skullduggery. My earliest dealings with the legal profession was in 1956, when my wife Margaret and I decided to buy our first home. The solicitor we instructed was Mr. Peck of Gates & Williams. Dealing with Mr. Peck was a privilege. He was a kind, efficient legal mentor who helped and guided my wife Margaret and I through many difficult periods. We trusted and relied on him many times. The standards adhered to by Mr. Peck were equal to the high standards and devotion depicted in many black and white films, standards which are no longer apparent. In simple terms, he was a noble, trusting, conscientious person, delivering the standards we the public have the right to expect and assume we get from our family solicitors. In 1962, my wife Margaret and I bought Broom Hall. It had been lacking in loving care and maintenance for many, many years, and in a very sad state of repair. Sadly, in 1975, after a very long illness, my dear wife Margaret died. Soon after, David Peck, my family solicitor and friend, was killed in a motor accident. At this point, I decided to seek out a solicitor nearer my home in Biggleswade, and Mr. Hall of Leeds Day was recommended. With the injection of money and new life into Broom Hall, it was soon promoted to a listed building status, and in 1984 I had the good fortune to secure a grant of £4,098 from the local authority to replace a lead roof. The grant conditions stated if I were to sell Broom Hall within 5 years, all or part of the grant may be claimed back by the local authority. I considered that to be a very fair and proper and a very reasonable condition. By 1987, the amount of work required keeping Broom Hall trim on my own became too demanding. I decided to sell, and I contacted Mr. Hall of Leeds Day, instructing him to act on my behalf regarding the sale. By mid-November 1987, Mr. Hall was made aware of the grant and its conditions. Regardless of the fact that Mr. Hall, on 3 separate occasions, had been informed about the grant and its conditions, firstly by myself, secondly by the local authority, and thirdly by the purchaser solicitors, Mr. Hall had neglected to attend to this very important matter. Consequently, shortly after completion, Mr. Hall contacted me to inform me there was a problem, and could I call at his office at my earliest convenience. Upon arrival at Mr. Hall's office, he explained he had neglected to attend to the matter regarding the grant conditions. However, he assured me there was no problem regarding completion because, on my behalf, he had agreed with the purchasers that an amount equal to the grant should be retained on trust by Leeds Day in the event of the local authority demanding repayment of the grant. Mr. Hall assured me that my £4,098 would be put on deposit in a trustee account with the Woolwich Building Society and retained for this particular purpose and this particular purpose only. I was somewhat disturbed by Leeds Day's negligence, but accepted it as human error. I simply had to accept both his negligence and his methods of conciliation as a fait accompli. I decided not to make a fuss. Early in 1993, I discovered some discrepancies in my investments managed by Knight Williams, financial advisors, and I contacted FINBRA, the financial regulators. As time was slipping by, I was somewhat concerned regarding the periods of limitation. So, I phoned Mr. Hall, my trusted family solicitor, simply to confirm limitation periods. Mr. Hall asked many questions regarding Knight Williams, and eventually told me this was not his area of speciality, and went on to explain the firm of Leeds Day offered their clients a free, no charge, 30-minute preliminary meeting with an expert to discuss matters that were concerning their clients. I went on to explain that Knight Williams was probably the largest firm of financial advisors in the UK with very, very deep pockets, and I would not be able to afford to take action against them. My prime concern was limitation periods. I also explained that FINRA, the financial regulators, had matters well under control, and I would be happy to leave matters in their hands. Nevertheless, Mr. Hall pressed the matter regarding a no-charge meeting. He went on to suggest that in the long term it would be to my advantage to be able to put a face to a name for future reference. I eventually accepted his generosity with grace and trust. Much later, with the eventual return of all my documents from Leeds Day, I was shocked to come across a surreptitious memo from Mr. Hall to Mr. Williams. In my opinion, this memo not only exposes inappropriate behavior, it exposes Mr. Hall's deliberate manipulation. I had been lulled into a false sense of security, with Mr. Hall leading me to believe he was considering my best interests. This was a confidence trick. One expects this sort of behavior and attitude from disreputable tradesmen, but not from one's trusted family solicitor. The arranged meeting with Mr. Williams took place on Friday the 8th of July 1994. As this was a meeting simply to meet Mr. Williams and put a face to a name, I took very little documentation. However, he said he was unable to give me answers regarding limitation periods without having sight of some documents to establish dates, etc. He also suggested I contact and consult with a financial advisor in Cambridge to establish what amount of money Knight Williams had misappropriated. Nevertheless, at no time did I hint or even suggest to Mr. Williams that I wanted him to take action on my behalf against Knight Williams. However, I did make an appointment with a financial advisor as suggested. On the 13th of July 1994, I received from Mr. Williams 2 letters of the same date. This was confusing, but the content even more confusing. One letter was thanking me for instructing Leeds Day to act in this matter, the other letter clearly stating, "I cannot do anything without your specific instructions." Also, Mr. Williams, having avoided my original question regarding limitation periods, requested further documentation. I gave no instructions to act. My meeting with Mr. Clark, Financial Advisors, Cambridge, convinced me I must await the outcome of FINRA. I then wrote letters to both Mr. Williams of Leeds Day and Mr. Clark of Browns of Cambridge, informing both that after due consideration I did not wish them to consider my dispute with Knight Williams. So far as I was concerned, that was the end of the matter. On the 19th of August 1994, I received a bill from Mr. Williams of Leeds Day headed, "For acting on your behalf in respect of a potential claim against Knight Williams." I couldn't believe it. I had not instructed Leeds Day to act, yet I am sent a bill. As I read on, it became obvious I had been conned. This was clearly a fraudulent demand for money. I had been conned into a no-charge preliminary meeting and sent a bill. It was no different to somebody putting tar on the drive of my house without instructions and knocking on my door demanding money. I responded, expressing my confusion and anger. I did not get a reply or an acknowledgement until I wrote a second letter stating, if this matter were resolved immediately, I would press the matter no further. But Leeds Day remained rigid regarding their fraudulent demand for money. Much later, that is, many years, I discovered the Solicitors Act clearly states Mr. Williams had a legal duty to obtain a signed agreement of acceptance from me before commencing any chargeable work. This confirms Mr. Williams' bill was an illegal, fraudulent demand for money. I eventually lodged an official complaint to Mr. Roberts, the managing partner of Leeds Day, and requested the return of all my documents. On the 24th of October 1994, Mr. Roberts, Leeds Day managing partner, informed me he had investigated my complaint. He advised me the account raised by Mr. Williams was entirely justifiable. Had Mr. Roberts investigated my complaint properly and honestly, by requesting sight of Mr. Williams' instructions to act, the absence of any instructions to act would have made him aware of the fact that Mr. Williams had not been instructed to act regarding this matter. I responded on the 26th of October 1994, explaining to Mr. Roberts, and I quote, "If it were only a matter of mere money, as you suggest in your letter, there would be no problem. Therefore, I suggest you, Mr. Williams, and Mr. Hall have another meeting and explore in a little more depth. It may be a little inconvenient now. Later, however, it will be difficult, if not impossible, to resolve this misunderstanding without much publicity and rancour." On the 9th of November 1994, I received a letter and completion statement from Mr. Hall. He confirms we discussed matters during a meeting in his office in 1988, when we agreed a sum equivalent to the amount of the original grant be retained on trust and put on deposit with a view to seeing whether the local authority ever responded and required repayment. He also confirms my money was deposited in a Woolwich Building Society trustee account, with himself as the named trustee. Mr. Hall goes on to say, we have subsequently removed the funds from the Building Society trustee account to the firm's client account. The completion statement clearly confirms my £4,098 was retained in respect of the Mid-Beds District Council grant, and clearly displays a deduction of £587.50 in payment of Leeds Day's fraudulent invoice. The transfer of my money to the firm's client account without my permission, or permission from the court, was a misappropriation of my money retained on trust. This was an unlawful act. On reading Mr. Roberts' letter dated December the 15th, 1994, clearly Mr. Roberts is fully informed regarding the reason my money was retained. He states, in the original contract there was an indemnity clause which reads as follows: "The vendor shall, upon completion, indemnify the purchasers against any liability in respect of the repairs grant in respect of the property." This is a very clear and unambiguous description of the particular purpose and trust. A letter from Mr. Roberts, dated November the 9th, 1994, arrived the same day as Mr. Hall's letter and completion statement. Mr. Roberts misquotes from the Guide to the Professional Conduct of Solicitors 1993, Annex 14E. He stated, quote, "The lien extends to all costs included in the matter in connection with which the money was received and applies to unbilled costs as well as unpaid bills." The direct quote from Annex 14E should have read, quote, "Practitioners are reminded that they have a lien on money belonging to the client which properly comes into their possession, unless the money is paid to the solicitor for a particular purpose, so that the solicitor becomes, in effect, a trustee of that money. The lien extends to all costs incurred in the matter in connection with which the money was received, and applies to unbilled costs as well as unpaid bills." Mr. Roberts cunningly omits the words of Annex 14E, which clearly confirms Leeds Day did not have any right of lien on my money in trust, as my money was paid to Leeds Day for a particular purpose, as confirmed in Mr. Roberts' letter of December the 15th, 1994, and many other letters and documents. Misquoting Annex 14E from the Solicitor's Guide to Professional Conduct is a blatant and deliberate fraud. The conspiracy to deceive and plunder is clearly beginning to unfold. Sending me a copy of Mr. Hall's memo to Mr. Williams was a very serious mistake on the part of Leeds Day. You see, honest persons like myself have little detailed knowledge on matters of law. We were brought up to work hard, and when things go wrong, seek advice and guidance from our trusted family solicitor. However, when one suspects one's trusted family solicitor of indulging in questionable, unlawful activities, one becomes very anxious and worried, because one is seriously concerned about the huge potential bills of hundreds of pounds an hour. However, having requested the return of all my documents, discovering Mr. Hall's surreptitious memo to Mr. Williams stirred me into making further detailed investigations into the wrongs of the whole situation, and was pleasantly surprised to find the laws of England and Wales not complicated, but made complicated by the legal industry. My receiving a copy of Mr. Hall's memo was indeed another very serious mistake on the part of Leedsday. The 1968 Theft Act very clearly and simply defines theft as, quote, "A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it." Clearly, there can be no doubt that Leedsday misappropriated money from trust, that is, Leedsday stole my money. This surreptitious memo exposes an absolute betrayal of my trust. On reading Mr. Hall's memo, I was disgusted by his conspiratorial delivery of information to Mr. Williams regarding my simple request for information on limitation periods. I was further disgusted by the conspiratorial ganging up of Leedsday's partners when informed of these illegal acts. If this could happen to me, it could happen to others. One might ask, why bother with such a small amount of money? Well, in today's value, it would be worth approximately £1,000, and I am sure if you were to discover your trusted bank manager had stolen £1,000 from your bank account, you would make a fuss until your trusted bank returned your money. In fact, if any trusted professional stole £1,000 from you, you would make a fuss until it was returned. Also, there are clearly two unlawful acts to be considered: a fraudulent demand for money and theft of money from trust. Much later, it occurred to me that Knight Williams' financial advisers were also trustees of my money. Trust law has no limitation period. Therefore, there was no period of limitation. Why did Mr. Williams, Leedsday's expert, press the matter as urgent when there was no need for urgency, and why didn't the expert regulators, the Law Society, identify and establish this fact during their investigations? What is the object of having experts, the Law Society, as regulators and guardians to protect the public against crooks within the profession if they do not understand the law? I began to prepare a complaint for the Law Society to investigate Leedsday's unlawful acts. Sadly, at that time there was much media publicity regarding the Law Society's questionable approach to complaints made against solicitors by their clients. Eventually, I decided, as the amount of money involved was not huge and the documented evidence was undeniable, I would use the small claims court instead. On the 28th of April 1995, I wrote to the Law Society requesting a copy of the rules regarding my situation, asking, "I seek to understand more clearly the right of lien and the obligations of solicitors regarding money held by solicitors as stakeholder trustees." On the 5th of June 1995, I received a reply from the Law Society enclosing photocopies from the Law Society's Rule Book, the Guide to the Professional Conduct of Solicitors 1993. Enclosed was Principle 2722 and 2732. These photocopies explain nothing of my core question regarding liens and trusts. Why did the Law Society withhold the clear information contained in the Law Society's Guide to the Professional Conduct of Solicitors 1993, Annex 14E, which clearly explains security for costs and/or lien, and clearly answers my questions about liens, and explains clearly the duties of trustee stakeholders? Annex 14E also clearly explains the duties and obligations of solicitors holding or retaining clients' money as stakeholder trustees. The Law Society provided me with no real honest guidance, just further confusion. This was a clear-cut case of abuse of power and fraudulent deception, i.e. misfeasance. I firmly believe the reason the Law Society was so reluctant to provide honest information was because the Law Society is subject to multiple conflicts of interest. Its prime function for its members was that of trade union and practice liability insurers. As inexperienced insurance agents, the Law Society established a debt of almost £500 million. At that time, it was compulsory for all solicitors to have exclusive insurance cover via the Law Society, and as a regulatory authority, this was a huge financial conflict of interest, bordering on illegality. I also believe, because of the overwhelming number of illegal acts committed by the Law Society members, the paying of compensation to clients was getting out of control. It appears this disastrous situation pressed the Law Society into taking advantage of their privileged position of being judge and jury in their own cause, causing concern within the Law Society of suffering the financial cost of any judgments against their members and bringing the Law Society into disrepute. Consequently, solicitors' fees were increased dramatically, and large London firms of solicitors rebelled, demanding the right to insure via private insurance companies offering more competitive rates. After researching in Bedford Library, I was left in no doubt whatsoever regarding Leedsday's fraud and theft from trust, and made inquiries regarding small claims court procedures. Having submitted irrefutable documented evidence to the small claims court, it was decreed by 2 county court judges the matter was too serious for arbitration in the small claims court. It was to be addressed in open county court. As a layperson, this concerned me. Nevertheless, so convinced was I that Leedsday had not observed the rules of law. Armed with ample, irrefutable documented evidence, I had no doubt that British justice would prevail. However, I did not take into account the unclean depths that Leedsday, a large, well-established firm of solicitors, would descend to hang on to their ill-got gains. On the 6th of February, 1995, a summons was issued to Leedsday, and the claim was, quote, misappropriation and removal of funds held in trust by Leedsday without agreement or permission. On February the 17th, 1995, I received a request, quote, for further and better particulars from Leedsday's barrister, Mr. Tettenborn. The request contained 3 main questions, which I answered simply and truthfully. I suspect Leedsday were not happy with my truthful answers, because on May the 10th, 1995, Leedsday requested further and better particulars in the correct format. The questions were exactly the same as before. I simply rephrased my answers simply and truthfully. Included with the request was Leedsday's defence, which clearly states, quote, it is admitted that the defendants deducted the sum of £587.50 from monies held on the plaintiff account from the sale of Broom Hall. Many years later, I secured a copy of Mr. Tettenborn's advice to Leedsday, also dated February 17th, 1995. On reading this, it became clear to me Mr. Tettenborn had been instructed dishonestly. Much later, in fact many years later, I discovered that had Leedsday submitted my honest answers to Mr. Tettenborn would have instantly realized Leedsday had instructed him dishonestly. I had no further correspondence with Mr. Tettenborn. He was replaced by another barrister, Mr. Gore. After a great deal of correspondence, on April 3rd, 1995, I wrote to Mr. Roberts expressing my opinions frankly, stating, and I quote, in my opinion, when Leedsday removed money from trust without my permission or permission from the court, Leedsday committed, as described in the Theft Act 1968, an act of theft. When exchanging witness statements in Leedsday's offices, Leedsday suggested, as I had no means of photocopying and producing the court bundles, they would be produced by Leedsday. On September the 25th, 1995, I received 2 copies of the court bundles from Leeds Day with clear instructions to deposit 1 copy in Peterborough County Court no later than 7 days before the court hearing. On reading the court bundles and preparing my case to present in court, I was very disturbed to discover many very important documents had not been included. So, on December the 5th, 95, I delivered 23 enclosures to Leeds Day, all clearly numbered, requesting they be included in Leeds Day's court bundle. I was daunted at having to cross swords with a large firm of solicitors and a barrister in the county court, and spent a tremendous amount of time researching in Buckingham University Law Library, preparing my case to present in Peterborough County Court. However, having done my homework, in my heart I knew what I was doing was right. On February the 9th, 1996, anxious to comply with Step 6 of the court's automatic directions, I drove to Peterborough County Court and delivered the agreed court bundle personally. A mere 3 weeks before the trial, I received 4 very confusing letters from Leeds Day. Firstly, Leeds Day telling me they were ready to exchange witness statements and intended exchanging these with me on Wednesday, January the 31st, 1996. As we had already exchanged witness statements and court bundles some months earlier, and I had prepared my case ready for court, I saw no point in responding to this letter. A few days later, I received another letter telling me Leeds Day would be grateful for a copy of my witness statement by return. I quote, "I enclose by way of service upon you the witness statements of Michael Williams and Brian Hall. Please acknowledge receipt when sending your own witness statement." No witness statements were enclosed. Some days later, I received yet another letter stating, and I quote, "We enclose by way of service upon you copies of the witness statements of Brian Hall and Michael Williams. These have, of course, already been sent to you in the trial bundles." The letter goes on to say, "We have reorganized the trial bundles as the previous documents were not identified individually." That is not true. When I submitted the 23 very important documents Leeds Day chose to leave out of the agreed bundle, I took great care to see they were all identified and numbered. It would have been less improper if Leeds Day had submitted the court bundles to me to inspect and take to Peterborough County Court. On reading the court transcripts, I suspect the court bundles were not all the same. 3 days later, another letter arrived from Leeds Day, which shook me beyond measure, stating, "We confirm that we have prepared our own witness bundle, and also the judge's bundle." On rereading the automatic directions, one clearly sees the intended wisdom of the automatic directions is to firmly establish the rules of procedure prior to entering the court. Little intellect is required to see that if the defendants were allowed to prepare the court bundle, the defendants would be most anxious to get away with their criminal acts by leaving out as many incriminating documents as possible. Hence, the court bundle must be prepared by the plaintiff. My opening statement to the court was my concern regarding the defendants' Leeds Day's violation of the court's automatic directions by submitting their own set of trial bundles with many new documents added. After some discussion, Judge MacArthur overruled my objections and stupidly allowed both bundles to be used. Needless to say, this start to the trial was very demoralizing for me, and this was compounded by Mr. Gore's, Leeds Day's barristers, persisting in a line of questioning not related to the charge as per the summons, to divert the court's attention from the charge on the summons, theft from trust, to the unrelated issue regarding the justification of Leeds Day's invoice. I had made the charge perfectly clear to Leeds Day in my letter dated 27th of June 1995. The prime question at issue is, did Leeds Day have right of lien on my money? I think not. As can be seen from the evidence, this was a deliberate and successful attempt to mislead the court and pervert the natural course of justice. I accepted the fact that the court services would provide an upright, fair, sober judge, fit for his duties, and I paid the court fees demanded. Within a short period of my court hearing, I discovered the court services had provided me with an unfit, twice convicted, self-confessed alcoholic judge. The court services, many barristers and solicitors, and Judge MacArthur's peers must have been aware of his previous convictions and his addiction to alcohol, but chose to ignore their duty and do nothing about it. Why didn't Judge MacArthur, an experienced county court judge, not press Mr. Gore to stick to the charge on the summons? In my opinion, Judge MacArthur permitted Mr. Gore to rule and manipulate his court to pervert the natural course of justice. I also suspect Judge MacArthur had not done his homework on this matter. The legal industry has made the laws of our land unnecessarily complicated. Consequently, we lay persons are very much at the mercy of the legal industry, and we trust them implicitly. In such extreme circumstances, I, as a layperson, found the rules and laws regarding lien very clearly written down and simple to understand. The rules and laws on fraud and theft are also very clear and not difficult to understand. The rules and laws regarding trusts are also clear and very understandable. These rules and laws are clearly explained in Halsbury's Laws of England, Stroud, and Cordray. In essence, it's a simple matter of honesty and common sense. Leeds Day, a large firm of solicitors, were fully aware of the fact that they had not been instructed to act regarding Knight Williams. They were also fully aware of the fact that they did not have right of lien on my money retained on trust. Yet, they were still prepared to instruct a barrister to defend their dishonesty in county court. These facts clearly demonstrate their intention to pervert the natural course of justice. Also, I suspect they were fully aware of Judge MacArthur's dependence on alcohol, and so chose to transfer the case from Huntingdon County Court to Peterborough County Court. On reading various documents, court transcripts, Mr. Tettimone's advice, and in particular the 2 letters I wrote to Leeds Day clarifying the charge on the summons, leading up to, during, and after the court hearing, one can appreciate the full extent of the manipulation applied by a large firm of solicitors and a barrister on a layperson defending his rights, and a self-confessed alcoholic judge to make a just judgment. In my opinion, Leeds Day, my trusted family solicitor, blatantly took advantage of this situation and perverted the natural course of justice. Having failed to secure fair play and justice in the county court, and fearful of further costly court costs and expenses, I lodged a fair and legitimate complaint against Leeds Day to the legal regulators appointed by Parliament, the Law Society. Meanwhile, I made an appointment and travelled to St. Albans, hopefully away from local influence, to seek independent, honest advice. At our first meeting, Mr. Kingsley, a young, very honest, and enthusiastic solicitor of Bretherton & Co., St. Albans, agreed to our meeting being tape-recorded. After much discussion, he was very confident I had a substantial case, and asked to meet again to view the documented evidence. Sadly, I can only assume he was influenced by his senior partners to not cooperate with me any further or persist with the matter. He chose to ignore my 8 letters and numerous phone calls. Having experienced such disgusting behaviour, manipulation and perversion of justice by Leeds Day and the court system in Peterborough County Court, after due consideration, and regardless of the bad media reports of the previous year regarding the Law Society's complaints procedure, I felt I had no alternative other than to present and pursue the illegal activities and disgusting behaviour of Leeds Day's fraud, theft, and perversion of justice via the Law Society. My confidence in the Law Society was uplifted when reading their information leaflets which explained the powers of the Bureau, referring to Acts of Parliament. Quote, to ensure that all solicitors observe proper standards of behavior and service when dealing with their clients and other solicitors. And mission statement, quote, to strengthen and maintain the confidence of the public and profession in the conduct and service of solicitors. With hindsight, I see these professional undertakings as manipulative and fraudulent. My legitimate expectation was that the Law Society had a legal duty to act fairly in accord with natural justice, whereas I was in fact damnified by an unreasonable and unlawful exercise of statutory power by a public body with a culpable state of mind, determined to obstruct the course of natural justice. I prepared and presented a very detailed, well-documented complaint to the Law Society. Suffice to say, their attitude was to belittle my complaint and support their trade union member Leeds Day. Regardless of the fact that I had submitted undeniable documented evidence regarding Leeds Day's fraud, theft, and perversion of justice, instead of the Law Society doing their duty and examining my complaint fairly, honestly, and without bias, as Parliament intended, the Law Society chose to don their trade union hat and rejected my complaint as unsubstantiated and supported Leeds Day's fraud, theft, and perversion of justice, telling me, if I was not satisfied with the result, I must lodge a complaint with the Legal Services Ombudsman. I, as did the two county court judges, considered the matter was far too serious for arbitration, and this was not the intention of Parliament. This dishonest attitude by a public body disturbed me greatly. Disturbed by the Law Society's attitude and unlawful support of their member Leeds Day, and dismissing my complaint, after a great deal of anxiety and concern, and considering the huge cost involved in taking anyone to court, let alone someone in the trade, a solicitor, I decided it would be less costly and more effective to make Leeds Day prosecute me. I prepared my video camera and drove to Leeds Day's Sunday office and videotaped myself smashing their window. I found this very difficult to do. I immediately returned home, made a duplicate copy, and returned to Leeds Day's offices to find the police attending. I handed them the videotaped evidence in the hope Leeds Day would prosecute me. I was arrested and imprisoned at Biggleswade Police Station for the remainder of the day. Leeds Day, in their wisdom, decided to suffer the full cost of repairs and withdrew all charges. One must ask why. I was recommended to consult Haggerty & Co., a firm of solicitors in Peterborough. I telephoned to make an appointment and spoke with Mr. K. Singh. I outlined the reasons I wished to consult with him, explaining my complaint involved the questionable services of a local solicitor. On my arrival at his office, I asked if I may tape record our meeting to enable me to revisit our meeting at leisure. His answer was a firm no. I chose not to press the matter and presented my evidence. On mentioning Mr. Hall, Mr. Sills, and other partners of Leeds Day, Mr. Singh spoke of them as familiar acquaintances. Having outlined my problem generally, I started asking questions, and at times the answers I received disturbed me greatly. Their ambiguity bordered on dishonesty. After some 50 to 55 minutes, I expressed my displeasure, paid my bill of £129.25, and departed. While driving home, I considered my meeting with Mr. Singh and decided he was another questionable solicitor, a fraud. I came away from Haggerty & Co. with nothing more than feelings of once again being deceived and cheated. On my way home, I decided to call at my bank and at my expense cancelled my cheque. On my return home, I instantly put pen to paper to Mr. Singh, explaining clearly what I had done and why. Included in my letter were 8 photocopies of documents and 2 questions. I stated, if Haggerty & Co. solicitors answer these questions honestly, I will happily reinstate my cheque, for £129.25. 11 days later, I received a letter from Mr. Singh telling me that as I had cancelled his cheque, he had, and I quote, no option but to confirm that he no longer acted for me. Having been deceived yet again, and having followed Leeds Day and the Law Society's criminal examples, I wrote to my local MP, Sir Nicholas Lyle, enclosing documents clearly explaining my predicament. Sir Nicholas Lyle wrote on my behalf to Mr. Tony Girling, then President of the Law Society. These actions pressed the Law Society into reopening and reinvestigating my complaint regarding Leeds Day's fraud, theft and perversion of justice. Following the legal profession's example of ignoring the law obviously paid dividends. I received a telephone call from Mr. Clements of the Law Society. We spoke for a considerable amount of time. He suggested a meeting with Mr. H.S. Griffiths, the Law Society's local conciliation officer, LCO, to enable him to compile a report and so enable Mr. Clements to investigate matters in depth. This time, before resubmitting my complaint, I secured a promise from Mr. Clements ensuring me the Law Society would investigate my complaint honestly and fairly. I trusted him and resubmitted my complaint. Mr. Griffiths, LCO, and I met for a total of 6 hours. I provided Mr. Griffiths with all the incriminating, indisputable, documented evidence regarding Leeds Day's fraud and theft, and answered all his questions simply and honestly. I also included photocopies from Halsbury's Laws of England, Stroud, Cawdry, and the Law Society's Guide to the Professional Conduct of Solicitors. These photocopies supported my claims unreservedly. Mr. Griffiths, LCO, submitted his report to the Law Society, who then proceeded to investigate. This investigation revealed the fact that Leeds Day had sought counsel's advice from Mr. Tettenborn, barrister. Despite Mr. Griffiths' report and honest recommendations regarding Annex 14E, Leeds Day's lack of right of lien, and the fact that Leeds Day had Mr. Tettenborn's advice confirming Leeds Day's misappropriation of my money from trust, the Law Society ignored their public duty. My complaint was once again unjustly rejected. This rejection prompted a great deal of correspondence between myself and the Law Society regarding my disagreement with the Law Society's committee's findings. The fact that Leeds Day had sought Mr. Tettenborn's advice, and I was not made privy to its content during the investigation, caused me to review the early documented investigations, more so the correspondence between Mr. Clements and Leeds Day. I requested sight of Mr. Tettenborn's advice and was refused. I again wrote and requested a copy of Mr. Tettenborn's advice and was sent a copy by mistake. I discovered the advice was dated 17th of February 1995, just 11 days after Leeds Day had received the court summons. Rejecting Mr. Tettenborn's advice and instructing Mr. Gore in his place confirms Leeds Day's intention to pervert the natural course of justice. On reading Mr. Tettenborn's advice, I felt duty-bound to inform the Bar Council of Mr. Gore's misconduct. After exchanging about 8 letters, it appeared the Bar Council were adopting the same attitude as the Law Society, defending their members' unlawful acts, intimidating and terrorizing a layperson into submission. Given this attitude, I felt I was not equipped to defend my right to justice against two such august institutions on 2 fronts. I again wrote to Sir Nicholas Lyle, who once again very kindly and dutifully wrote on my behalf to the Lord Chancellor, Lord Irving of Legg, making him fully aware of my predicament. Lord Irving of Legg replied ambiguously, appearing to support his peers. Having my complaint against Leeds Day continually and unlawfully rejected by the Law Society and Bar Council, I decided, after considerable thought, to remove the nameplates from the Law Society and Bar Council London offices, in the hope that my actions would concentrate and stimulate minds into further action regarding Leedsday's unlawful acts. My thinking was, if I could press the Law Society into prosecuting me, this would expose their unlawful attitude and acts. To save police time, I faxed the London police to make them aware of my actions. In my opinion, my action and attitude was no different to Leedsday and the Law Societies. That is, if you can't get the required result within the rule of law, ignore the law. A few days later, the London police phoned, telling me I would be prosecuted. To their surprise, I responded, "That's fine, you have my name and address, etc. I await prosecution." A few days later, I phoned the police asking what was happening. I was informed, in their wisdom, the Law Society and Bar Council had withdrawn all charges and I could keep the nameplates. One must again ask why. June 2001. I reported Leedsday's unlawful acts of fraud, theft, and the perversion of natural course of justice, and the reluctance of the Law Society to take action, to the Bedfordshire Police. 2 Bedfordshire police officers visited my home to take details. They agreed to this meeting being tape recorded. Despite this apparent interest, the Bedfordshire Police did not pursue matters. I was unable to understand why action was not taken by the Bedfordshire Police. At that time, I suspected some form of collusion, cover-up, or reciprocal scratching of backs. Having exhausted all correct and proper procedures, and experienced the unlawful, despotic, terrorizing attitudes of the Law Society, Bar Council, and police when acting as public bodies, I was left with no alternative other than to once again follow the example of our legal mentors, come tormentors, Leedsday and the Law Society. That is, if you cannot get the required result within the rule of law, ignore the rule of law. After a tremendous mental autopsy, I decided such a drastic situation warranted drastic, direct action. I began to plan and prepare myself and my motorhome for a protest outside the Law Society in Chancery Lane, London. Unsure what to expect, I stocked up for a long, drawn-out protest. My demonstration was never intended as a bomb threat. It simply evolved that way because of the Law Society stubbornly deciding to ignore my notices clearly and boldly displayed on my vehicle. I was looking for no more than the Law Society to do their duty as prescribed by Parliament, that is, to ensure equity in justice. I parked outside the Law Society in Chancery Lane at about 3 p.m. Many people came out of the Law Society to read the notices posted on my vehicle. Eventually, one individual told me I could not park here with notices like that. The Law Society notified the police, and about 6:20 p.m. a police constable arrived and asked many questions. I explained in detail that I had exhausted all proper procedures of the complaint system within the Law Society and have no choice but to resort to direct action to resolve my complaint against Leedsday. Having delivered a substantial summary of my complaint, a large file, which included copies of the original documents, Halsbury's, Stroud, and the Law Society's Guide to the Professional Conduct of Solicitors, there were some 36 hours of discussion and negotiations with the Metropolitan Police acting as conciliators. This was very successful because, with such a comprehensive file being inspected by the Law Society and the Metropolitan Police, the Law Society were unable to respond in any way other than honestly, and within the rule of law. Consequently, when my 3 questions were put to the Law Society by the Metropolitan Police, Mr. Whitehead, Chairman of the Law Society's Civil Litigation Committee representing the Law Society, had no option other than to provide me with honest answers to my 3 important questions in a letter from the Law Society signed and delivered to me personally. On receiving these 3 honest answers, I was promised my complaint would be reopened, reinvestigated, and a written review produced and delivered to all those concerned, and my complaint reconsidered. I immediately stood down from my demonstration. I had no idea my demonstration was causing so much disturbance in central London. On stepping out of my van, I was surrounded by police, marksmen aiming to kill, not maim, producing red laser dots on my chest from sights of their guns. I was then treated as a common criminal, taken and detained in Charing Cross Police Station prison cells. Had the Law Society, when acting as a public body, investigated my complaint honestly and without bias, I would not have been pressed into following their criminal example and smashed Leedsday's window. However, my illegal act was clearly understood and effective. The Law Society reopened and reinvestigated my complaint. Had the Law Society, when reinvestigating my complaint for a second time, investigated it honestly and without bias, I would not have been pressed once again into following their unlawful example. I would not have removed the nameplates from the Law Society's offices in Chancery Lane. Once again, had the Law Society answered my 3 simple questions within the first 3 hours of my demonstration, and not involved the police to do their dirty work, the City of London would not have been put to such huge inconvenience and tremendous cost. I would not have had to suffer such humiliations and a prison sentence of 1 year and 3 months because of the illegal acts of my solicitor and the Law Society. While in Charing Cross police prison cells, I was advised to employ a solicitor and was approached by the duty solicitor. After long discussions, clearly explaining my situation, I once again put my trust in a solicitor and allowed myself to be advised by the solicitor to respond to the police questions with no comment. On reflection, my solicitor's advice caused me to appear uncooperative to the police and probably did my situation more harm than good. Initially, both the solicitor and barrister understood my complaint against Leedsday and the Law Society, and I felt greatly encouraged. However, over the following few weeks, this understanding attitude changed. I can only suspect they had been got at by the Law Society and Bar Council. However, the bail court judge appeared to have done his homework and granted me conditional bail. On trial at Southwark Crown Court, I feel certain neither Mr. Pitt nor Judge Bathurst Norman considered the extreme reasons and extenuating circumstances surrounding the reasons of my actions. Had these factors been considered and properly assessed, in the interest of justice, the court would have been duty-bound to recommend an inquiry. On reading the court transcript, I feel Mr. A. Pitt, the barrister representing me, did not present my case justly and with the flair expected of a barrister about to be promoted to the status of judge. His lack of quality and enthusiasm in delivering my case resulted in the media interest being minimal. Much to my surprise, Judge Bathurst Norman sentenced me to 1 year and 3 months in Brixton Prison. My feelings of sorrow, sadness, and shame for my family and friends were far greater than the fear of what was to come for me. Somehow I was lost in the system and found myself in Pentonville Prison, a prison containing the most disgusting and violent of people. The period of isolation from my family and friends in Pentonville Prison magnified my disappointment and exposed the corruptness of a select esoteric group that appeared to manipulate the British legal system so cunningly and so evilly. I vowed to expose the cost to the public purse and the enormous squandering of public money, defending Leedsday's fraudulent theft from trust and the subsequent perversion of justice. I also vowed to expose all that took part in this evil cover-up, in particular the public officers who are given and abuse the privilege of maintaining a high standard in our British legal system, and who in a given year laid claim to in excess of £2 billion in legal aid. That equals 2 new hospitals or 47,000 more police officers. In jail, with the help of friends and family, I continued my research. This period of solitude made me very aware of the fact that it was compulsory for all solicitors in England and Wales to be insured exclusively via the Law Society, the Solicitors' Trade Union, and no outside insurance was permitted. The Law Society had a monopoly on solicitors' liability insurance and were, in my opinion, anxious to keep any insurance liability payments to solicitors' clients who complained to a bare minimum. This is blatant deception, manipulation and fraud by the Law Society against members of the public who have legitimate complaints against solicitors. It must also be kept in mind that the Law Society had been given the privilege and instructed by Parliament to regulate solicitors as a public body. The failure to do so honestly, without bias, results in misfeasance. Under such circumstances, the Law Society themselves are breaking countless laws and abusing their powers. Due to my research and persistent letter writing while still in prison, I received the long-awaited review of the handling of my complaint by the Law Society. I am given to understand that my complaint was investigated, reviewed, and written by Anne Fuller, a Law Society committee layperson, and approved by Mr. Salisbury, Secretary to the Law Society Compliance Board, and delivered to me with his letter dated September the 20th, 2002. These are but a few quotes exposing the Law Society's negligence. Paragraph 18. I quote, "It was Mr. Dowling's only contention from the start that it was unlawful, certainly against the Law Society rules, for the solicitors to take their costs from a sum being held for a specific purpose. See Annex 14E. Paragraph 32, and I quote, "The office error was compounded by a letter written to Mr. Dowling on the 29th of May. A second letter from the Law Society, dated 6th of June, 1996, again completely ignored the issues Mr. Dowling had requested the Bureau to investigate and displayed a lack of understanding of the obligations of the Bureau." Paragraph 33, and I quote, "The true legal position of the Bureau was its duty to investigate the complaint of misconduct. This should have been understood by the Law Society. It cannot be right, however, that the judgment of a court deprives the complainant of a right of redress for poor service given to him by Parliament." Paragraph 34, I quote, "Where another tribunal has made a decision or judgment, and where a party comes before us and asks us to consider facts or arguments relevant to our powers and within our jurisdiction, we must consider these fresh facts or arguments. I would go so far as to say that not only would it be manifestly unjust not to do so, but it would be wrong in law if we did not." Paragraph 65, I quote, "Mr. Mount of Leedsday replied on the 3rd of December enclosing counsel's opinion, which he said was not to be disclosed to Mr. Dowling. The Law Society were now in possession of Mr. Tettenborn's advice confirming Leedsday's unlawful acts. The Law Society chose to continue to ignore their duties as public officers and persisted in defending their trade union members and did not permit me sight of this advice." Paragraph 94, I quote, "The Law Society's caseworkers' report, which was put to the committee, found that Leedsday did not have right of lien and therefore misappropriated the money and recommended a rebuke." Unquote. This theft was not reported to the police. Paragraph 95, I quote, "The decision of the Law Society's Appeals Committee, given to Mr. Dowling by letter dated 7th of July, was that all complaints were unsubstantiated." Paragraph 107, Errors. I quote, "Had the significant errors not been made by two members of the primary investigating unit of the Solicitors' Complaints Bureau in April and May 1996, this complaint would have been investigated from the start and the solicitors obliged to explain their actions. Instead, it was 16 months after the complaint had been made before Leedsday were asked for their comments. The error regarding Mr. Dowling's status was caused by an inadequate perusal of the papers, and that concerning the obligations of the office to investigate betrayed a lack of knowledge of its jurisdiction. Paragraph 115. Recommendations. I recommend that this case should now be referred to a reconsideration committee. The Law Society had a legal public duty to ensure a fair and honest investigation into my complaint. Acting as a public body, the Law Society had no legal right or just cause to withhold, suppress, or ignore Mr. Tettimord's advice at the behest of the defendants Leeds Day. When a public body is investigating a complaint, all evidence must be available for inspection by all concerned, particularly when such serious offences as fraud, theft, and the perversion of justice were clearly documented and presented for investigation. I was not prepared to kowtow to bullies. In fact, I was prepared to stand up and be counted regardless of the consequences. Eventually, the cunning and dishonesty of the all-powerful Law Society proved to be far greater than I expected, resulting in my being sent to prison for 1 year and 3 months. On my release from prison, all the information confirming Leeds Day's fraud, theft, and perversion of justice was sent to the Chief Executive and senior members of the Law Society. It was very detailed and set out in 4 simple phases containing easily understood documents. Over the years, all this clear-cut documented evidence was on more than one occasion delivered to the Law Society. Regardless of the Law Society's Caseworkers Report of 2000 and letter to me dated 12th of January 2002 confirming Leeds Day's unlawful acts, and the Law Society's review of my complaint recommending my complaint should be referred to a reconsideration committee, the Law Society again ignored their legal duty and unlawfully decided my complaint should not be reopened and reconsidered. One must ask why. December 2002. I again met with Mr. Alistair Burt, Member of Parliament, formerly a solicitor. We reviewed the documented evidence, and he agreed from what evidence he had seen Leeds Day had misappropriated my money retained on trust. He said he had arranged a meeting with the Law Society, and it was agreed we would await the outcome of the review committee's report. In the meantime, the Law Society decided once again to renege on their promise and ignore their parliamentary duties, and I heard no more from our Member of Parliament, Mr. Alistair Burt. Again, having confirmation from the Law Society on January the 12th, 2002, that Leeds Day had fraudulently misappropriated my money retained on trust, and subsequently perverted the natural course of justice, while in prison, I decided to again report all unlawful acts by Leeds Day, the Law Society, the Bar Council, and all concerned to the Bedfordshire Chief Constable. Paul Hancock, Bedfordshire's Chief Constable, replied stating he had passed the information on to DCS Jeff Coombe, who will be in contact shortly. Jeff Coombe wrote stating he was unclear of the allegations made and whether any offence took place within the Bedfordshire area. Leeds Day's Sandy offices are well within Bedfordshire. Having no documentation in prison, I replied to DCS Jeff Coombe the following January with comprehensive details of the crimes and supporting documents. DCS Coombe replied that he would investigate matters. After a very long delay of almost 2 months, I wrote to inquire what progress had been made. On the 23rd of April 2003, DCS Coombe replied, "I have now had the file reviewed, and it is our opinion that there is no evidence to support an allegation of criminal misconduct, and it appears that this is a civil dispute between yourselves and Leeds Day." This statement I question, as the Theft Act of 1968, Halsbury's, Cawdry, and Strout all confirm fraud, theft, and the perversion of justice are serious criminal acts. Unable to understand this attitude, I reflected on previous calls for police help and was unable to understand why action was not taken by the Bedfordshire Police. I later discovered there was, and still is, a memorandum of understanding between the Association of Chief of Police Officers of England and Wales and the Law Society. The conclusion of this memorandum clearly states they, and I quote, recognise and respect their different statutory duties. However, in the public interest they commit themselves to improve professional cooperation and to systematic exchange of information. Their joint campaign against dishonesty and default involving solicitors or their employees. Would one consciously deal with any profession who has an arrangement with the police with the potential to give that profession absolute power, thus putting that profession above the law? The public duty of the Law Society and the police overrides any questionable memorandum of understanding. As can be seen, agreements of this nature can result in concealment of unlawful acts. To quote Lord Acton, power tends to corrupt, and absolute power corrupts absolutely. When all else fails, one writes to the boss. Over the years, I wrote to many senior officers at the Law Society with no success. After receiving a letter from the Law Society confirming Leedsday's fraud, theft and perversion of justice, I stood down from my demonstration in Chancery Lane. On my release from prison, I again wrote to the senior officers of the Law Society, convinced my complaint was in the embryonic stage of resolution. The Law Society CEO, Janet Paraskeva, replied, "The Law Society await," and I quote, "further consideration of your complaint is a matter for the Compliance Board." As we now know, the Law Society Committee unlawfully decided my complaint should not be reopened and reconsidered. Janet Paraskeva then wrote to inform me, and I quote, that so far as the Law Society is concerned, that concluded the matter, and there is nothing further which can be added. I replied with a letter and 14 enclosures on March the 17th, 2003, but to my surprise, Janet Paraskeva never did reply. I persevered, writing letters to the Law Society, pressing my point and referring to their admission of Leedsday's criminal acts in the Law Society's letter dated January the 12th, 2002, and their parliamentary duty. I continued my research into the duties of public officers, public duty, breach of duty, misconduct of public office, and culpability of the senior officers, partners, and their firms. I decided to write and inform them all of the unlawful acts committed and their duty as sworn solicitors, officers of the court, to report crimes. On November the 13th, 2003, I submitted a compilation of documents from the Theft Act 1968, the Solicitors Act 1974, and Halfreys in the form of phases clearly confirming the criminal acts of Leedsday, and was sent to each firm of the Law Society President, Vice President, and Deputy Vice President. Some of the people and firms I have informed to date of Leedsday's crimes are Mr. Whitehead of Russell, Jones and Walker, Janet Paraskeva, Law Society CEO, Carolyn Kirby, Law Society President, Peter Williamson, Law Society President, Edward Nally, Law Society President, Kevin Martin, Law Society Vice President, Fiona Wolfe, Law Society Deputy Vice President, Nigel Phillips, Senior Partner of Lodders Solicitors, John Webber, Senior Partner of Russell, Jones and Walker, Joseph Richardson, Senior Partner of Dawson's Solicitors, David Porter, Senior Partner of Fielding's Porter, and many others. 10 months passed since I wrote to Janet Paraskeva, and on the 21st of January 2004 I received a letter from her asking if I would be, I quote, amenable to the idea of independent mediation. Arbitration is what Miss Paraskeva of the Law Society means. The law very clearly defines fraud and theft, and when these unlawful acts are perpetrated by trusted solicitors, they are far too serious for arbitration. This was confirmed by 2 county court judges in 1995, and it is the Law Society's legal duty to investigate and resolve these matters honestly and without bias, not abrogate their duties by again pressing for arbitration. I declined the Law Society's offer of arbitration and have asked them to concentrate on their legal duty. So far, in 2004, 10 years since my money was stolen from trust by Leeds Day, the Law Society have made small offers of money to resolve matters, barely sufficient to cover postage, provided I, and I quote, would agree not to pursue this matter any further. That is, to sign a gagging order, yet refused to acknowledge Leeds Day's criminal acts, as did Mr. Whitehead when representing the Law Society on January the 12th, 2001, and only chooses to acknowledge that my complaint has been mishandled by the Law Society, and flatly refused to take any disciplinary action against Leeds Day and the solicitors involved. Perhaps the fact that Mr. Williams of Leeds Day, now Woodfine Leeds Smith, has recently been promoted to represent litigators of England and Wales within the Law Society has some bearing. I did not set out in life to make a movie about disreputable solicitors, the troubles one might have with the Law Society failing in their public duty, or follow their unlawful examples. In fact, because of my early dealings with Mr. Peck, I had the greatest respect for solicitors, the Law Society, and the British legal system. What has made me pursue this matter so enthusiastically for so long, and how do I justify my actions? Well, firstly, I was deceived by my trusted family solicitor's fraud and theft. Secondly, I was deceived by the county court providing an alcoholic judge, thus allowing the perversion of justice. Thirdly, I was deceived by the Law Society supporting their members' fraud, theft, and perversion of justice. And fourthly, I was deceived by the police, who had a memorandum of understanding with the Law Society and neglected to inform me. I had the greatest respect in all these public bodies, and had followed all the correct procedures, but found myself battling against a 2-tier legal system. The Law Society's lack of interest in justice has brought me to the point of making this movie and designing a website to inform and warn everyone of the 2-tier legal system operated by some unscrupulous members of the legal profession, who are then supported by the Law Society of England and Wales. Solicitors are very intimidating. They manipulate our trust and our trust in the system. Consequently, the rogue element within the profession rip clients off. The unlawful acts of these dishonest solicitors are then supported by the Law Society, who fear suffering the huge costs of being honest in their judgment as insurers. In so doing, the Law Society become judge in their own cause and abuse their power of public office. This agreement makes a mockery of Magna Carta, which clearly states, and I quote, "No one shall buy or sell justice." In 1988, Leeds Day retained £4,098 of my money for a particular purpose. Therefore, by virtue of Section 21(1)(b) of the Limitation Act 1980, Leeds Day were, and still are, constructive trustees. In 1994, Leeds Day were not in my employ regarding Knight Williams. Therefore, Leeds Day fraudulently stole money retained on trust and went on to pervert the natural course of justice in the county court. The stance adopted by Leeds Day was, "See you in court." This attitude adopted by solicitors is intimidating to the point of terrorizing clients into submission, knowing full well that the cost of solicitors, barristers, and court costs are weighed beyond measure against the client. When I decided to call Leeds Day's bluff as litigant in person in the Small Claims Court, Leedsday, with intent, resorted to abandoning and ignoring the rule of law to pervert the natural course of justice. When I followed the example of Leedsday by ignoring the law, and called their bluff a second time by smashing their window and pressing them to prosecute me in court, after due consideration they stood down and withdrew all charges. This attitude of "see you in court" was repeated by the Law Society and the Bar Council, intimidating and terrorizing me with their all-powerful status. When I called their bluff by removing the nameplates and informing the police, pressing them to prosecute me, after consideration they were well aware they didn't stand a chance of prosecuting me successfully because of their unlawful regulation. They withdrew all charges, and I still have these nameplates. When push came to shove outside the Law Society offices in Chancery Lane, there were 3 hours between 3 p.m. and 6 p.m. whereby the Law Society and I could have negotiated an honest, reasonable, law-abiding settlement. However, after due consideration, the Law Society decided to manipulate the police to get them to do their dirty work. I also firmly believe the firm of solicitors and barrister representing me in court had been got at by the Law Society and the Bar Council. In court, the extenuating circumstances which drove me to such extreme measures were not properly nor fairly put forward in my defence. Why? Why did Leedsday, a large firm of solicitors, feel the need to instruct 2 barristers to defend themselves against 1 layperson? Why did the court services provide an alcoholic judge? Why did Judge MacArthur not address the charge as per summons? Why have successive governments allowed the Law Society to continue with the privilege of self-regulation when it is a clear conflict of financial interest and working dishonestly? In 1975 there were approximately 25,000 solicitors in England and Wales. Today we have over 100,000 solicitors. Is our nation better off and happier? I think not. The laws of our land have been hijacked by disreputable members of the legal profession. The actions of these disreputable members must be brought to account. What is the alternative? Direct action. The question which must be asked is, to what extent does one have to go to obtain justice? I now question the integrity of the British legal profession and legal system, and look to the British people to press Parliament to return the hard-won benefits of British common law to us, the common people of Great Britain. As Lord Denning made very clear, the law was to serve the people and not vice versa, and no one was above it.